This is Constitutional Rights in Black and White.
In 1995, Jim Obergefell and John Arthur fell in love in Ohio. They moved into the same house and built a life together. But in 2011, John was diagnosed with ALS, an incurable disease. Jim and John resolved to marry before John died. They flew to Maryland, where same-sex couples could legally marry. John was too sick to move, so they got married inside the medical transport plane sitting on the tarmac in Baltimore. 3 months later, John died. But Ohio wouldn't recognize their Maryland marriage and refused to list Jim as the surviving spouse on John's death certificate. Jim described this as hurtful for the rest of time. April DeBoer and Jane Rouse were nurses in Michigan who had been together for many years. In 2009, they became foster parents too and then adopted a baby boy. That same year, they adopted an infant who required around-the-clock care. The next year, they adopted a baby girl who had special needs. But Michigan wouldn't permit unmarried couples to adopt children together, and same-sex couples couldn't marry in the state. So each child could only have one woman as their legal parent. In an emergency, April would have no legal rights to take care of the child who Jane adopted, and vice versa. Jim and April and Jane, along with others who were members of same-sex couples, sued the states in which they lived. Their cases went to the Supreme Court, where they argued that they had a constitutional right to get married and to have their legal marriages in one state be recognized by all other states. Yes, said the Supreme Court, you do have the right to marry. This court has long held the right to marry is protected by the Constitution. And the Constitution protects you too. But wait, said Ohio and Michigan and the other states involved. Marriage has historically been understood as a union between a man and a woman. That's true, said the Supreme Court, but the history of marriage is one of both continuity and change. And fundamental rights protected by the Constitution evolve too. History and tradition guide and discipline the fundamental rights inquiry, but do not set its outer boundaries. Just because same-sex couples have been excluded from marriage in the past doesn't mean they should be excluded now. After all, if rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, and new groups could not invoke rights once denied. Bottom line, denying same-sex couples the right to marry impermissibly deprives them of a fundamental right and imposes unconstitutional inequality. Laws excluding same-sex couples from the marriage right impose stigma and injury of the kind prohibited by our basic charter. The states argued that this was a big political decision. Shouldn't the Supreme Court hold back and let the political system work it out? No, said the court, we have a constitutional obligation to decide. It is of no moment whether advocates of same-sex marriage now enjoy or lack momentum in the democratic process. The issue is whether the Constitution protects the right of same-sex couples to marry. And it does. Obergefell was a momentous decision, changing the landscape of LGBTQ rights and family law. It's a landmark example of how constitutional law can evolve over time and in ways that may be more consistent with modern understandings of rights, relationships, and equality. Okay, let's read the case. Obergefell versus Hodges arose after decades of conflict over same-sex marriage. Litigation dates back to the 1970s, and states began to open marriage to same-sex couples in the 2000s through judicial decisions and eventually through legislative and electoral decisions. In 2014, the Sixth Circuit ruled against same-sex couples in cases challenging marriage bans in Kentucky, Michigan, Ohio, and Tennessee. The court considered these consolidated cases in Obergefell. The court granted review to consider two questions about the 14th Amendment. One, do states have to license a marriage between two people of the same sex? And two, do states have to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state? Now, ordinarily, under family law principles, a marriage valid where celebrated is valid everywhere. But states like Ohio refuse to recognize same-sex couples' marriages from other states. This is an opinion written by Justice Kennedy. He had written all of the court's major LGBTQ rights decisions. Romer versus Evans, striking down a Colorado constitutional amendment that precluded anti-discrimination protections for lesbian, gay, and bisexual people. Lawrence versus Texas, striking down Texas's criminal law prohibiting so-called homosexual conduct and ruling more generally that anti-sodomy laws are unconstitutional. And United States versus Windsor, striking down the part of the Federal Defense of Marriage Act that precluded the federal government from treating valid state law marriages of same-sex couples as legal marriages. Justice Kennedy begins Obergefell by explaining, and in some ways justifying, the court's role in substantive due process matters. The identification and protection of fundamental rights is an enduring part of the judicial duty to interpret the Constitution, he explains. And it requires courts to exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. Justice Kennedy understands the court's approach here as consistent with a number of modern substantive due process decisions that have protected fundamental rights widely accepted by the public. These include rights to privacy, sexual autonomy, family integrity, reproductive rights, parental rights, and as here, the right to marry. A substantive due process analysis begins by asking whether there is a fundamental right at stake, one deeply rooted in history and tradition, and implicit in the concept of ordered liberty. Justice Kennedy clearly sees a role for history and tradition, but he cautions that history and tradition guide and discipline this inquiry, but do not set its outer boundaries. Justice Kennedy frames the right at issue here broadly, as the right to marry. In contrast, the dissenting justices would frame the right more narrowly, as a right to same-sex marriage. You can see how simply observing the framing of the right tells you much about how the justices will reason about the question. A right framed in broader terms is more likely to be seen as fundamental, thus triggering heightened scrutiny, while a right framed more narrowly is less likely to be seen as fundamental, and therefore likely subject only to rational basis review. The dissenting justices cite Washington versus Glucksberg as the governing decision for fundamental rights analysis. That case involved physician-assisted suicide, and the court rejected the fundamental rights claim. In doing so, Chief Justice Rehnquist, a conservative, qualified the traditional fundamental rights approach by adding key words of limitation. He explained that the court must engage in a careful description of the right at stake. And that means a narrow framing at a very specific level. He also explained that to qualify as fundamental, the right must be objectively deeply rooted in this nation's history and tradition. In other words, there must be concrete and uncontroverted evidence that the right is deeply rooted in U.S. history and tradition. Non-U.S. authorities are not relevant on this approach. In Obergefell, Justice Kennedy rejects this formulation, reasoning that it is inconsistent with the approach this court has used in discussing other fundamental rights, including marriage and intimacy. Justice Kennedy illustrates that Glucksberg's more narrow framing is not how the court has reasoned about the right to marry. For example, he explains, Loving versus Virginia, which struck down Virginia's interracial marriage ban, did not ask about a right to interracial marriage, but rather inquired about the right to marry in its comprehensive sense, asking if there was a sufficient justification for excluding the relevant class from the right. What's the reason to approach the analysis in this way? If rights were defined by who exercised them in the past, he explains, then received practices could serve as their own continued justification, and new groups could not invoke rights once denied. Justice Kennedy then gives us 4 principles and traditions that illuminate the reasons why the right to marry is fundamental. And he concludes that these reasons apply equally to same-sex and different-sex couples. First, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry supports a 2-person union, unlike any other in its importance to the committed individuals. Third, the right to marry safeguards children and families, and thus draws meaning from related rights of child-rearing, procreation, and education. So note that this understanding of marriage includes both a non-procreative, adult-centered view and a procreative, child-centered view, both of which can include same-sex couples. Fourth, and finally, marriage is a keystone of our social order. Notice how much this reasoning, and reasoning throughout the opinion, privileges marriage. Marriage is the foundation of the family and of society, without which there would be neither civilization nor progress. Marriage responds to the universal fear that a lonely person might call out only to find no one there. Gays and lesbians' hope is not to be condemned to live in loneliness. The dissents disagree with the majority, not about the importance of marriage, but instead about the meaning and purpose of marriage. They see marriage as traditionally and primarily about procreation, and by that they mean sexual procreation, and the biological, dual-gender child-rearing that flows from it. Chief Justice Roberts asserts that, for the good of children and society, sexual relations that can lead to procreation should occur only between a man and a woman committed to a lasting bond. Justice Alito explains that states formalize and promote marriage to encourage potentially procreative conduct to take place within a lasting unit that has long been thought to provide the best atmosphere for raising children. For these justices, if marriage is really about sexual procreation and dual-gender parenting, then it is inconsistent with what same-sex couples are seeking. This reasoning supports the conclusion that same-sex couples are not asking for a fundamental right, but something different and narrower, a right to same-sex marriage. But this view loses. Instead, the court finds that same-sex couples can claim the fundamental right to marry because the right's core attributes and principles are equally applicable to them. Obergefell was an historic decision about marriage and LGBTQ rights, but it also made some unconventional and important doctrinal moves. For example, where fundamental rights are at stake, the court usually applies strict scrutiny, but we don't see that here. When the court finds that a law is unconstitutional on due process grounds, it usually wouldn't reach the equal protection question. But here the court holds that denying same-sex couples the right to marry also constitutes an equal protection violation. The equal protection analysis itself is also noteworthy. Usually, equal protection analysis requires a discussion of protected classes and tiers of scrutiny, but we don't see that here. The case also airs some major disagreements about constitutional methodology and institutional competence. The majority takes what might be called a living constitutionalist view, seeing the open-ended provisions of the Constitution, like liberty and equal protection, as deliberately and rightly left for elaboration by subsequent generations. By contrast, the dissenters focus on textually enumerated rights and original understandings, approaches that they assert would preclude same-sex marriage. And the dissenters argue that the majority is essentially reading rights into the Constitution that do not exist. This is in part what Chief Justice Roberts means when he hurls the epithet Lochner at the majority. The discredited Lochner case encapsulates the charge of illegitimate judicial decision-making. That is, when the court is announcing rights based on its own personal and policy preferences. The dissenters also invoke Lochner to offer an institutional critique, an argument that the court is intervening in democratic politics, acting more as a legislature than a court. The majority, of course, doesn't understand what it's doing as illegitimate. It sees itself reasoning about a constitutional right, the right to marry, that has long been protected and accepted as a core element of rights protected by the Due Process Clause. It is ensuring that fundamental rights are not left to the whims of majoritarian politics, but are protected against infringement. And it is intervening only after decades of conflict and debate, including social and political mobilization, state and lower federal court decisions, legislative change, and ballot initiatives. In this sense, the court sees itself as appropriately responsive to shifting constitutional understandings in other institutional arenas and in the public. The decision in Obergefell is the result of decades of social movements, public education, and litigation. And along the way, there was a lot more losing than there was winning. In the early years of the gay liberation movement, same-sex couples challenged these same kinds of marriage laws, but courts quickly and easily rejected those challenges. When one of those cases reached the Supreme Court in 1972, the court dismissed the appeal for want of a substantial federal question. Today, it would be unimaginable to think that marriage equality doesn't implicate a federal question. Times have changed. Obergefell also tells us something important about the role of the court itself, that it is in conversation with social and political changes. Justice Kennedy writes about the many central institutions in American life that have been thinking differently about LGBTQ issues, including governments, the military, the private sector, and religious organizations. This analysis presents a model of judicial review that Professors Riva Siegel and Robert Post have called democratic constitutionalism, seeing a democratically legitimate role for courts in responding to political and social mobilizations and changing understandings emerging from other institutional arenas. Obviously, Obergefell was a momentous decision for same-sex couples and their families. But it also teaches us a lot about the relationship between law and culture, between social movements and constitutional interpretation, and between democratic conflict and judicial review.
I'd like to thank Professor Doug Nijem for contributing this important case video to CRBW. Professor Nijem is one of the nation's leading scholars of family law and parenthood, of same-sex rights, and of constitutional law. In particular, he's been a leader on national efforts to reform parentage laws to accommodate families that feature non-biological parent-child relationships, including families formed by same-sex couples and through assisted reproduction. We're very lucky to have his contribution to the casebook.